National Labor Union, the case petitioner filed accusations against Insular-Yabana Tobacco Corporation in the Court of Industrial Relations, accusing the company of discriminatory firings of its 3 employees, Juana Torres, Dominador Gonzalez, and Honorato Gabriel. In a trial for unfair labor practices, according to Section 5 of Republic Act No. 875. Can the court give a remedy like reinstatement and back pay even if the complaint is thrown out because the unfair labor practice that was supposed to be done has not been proven and found to exist? Judge Arsenio Martinez heard the cases, and in his decision on December 26, 1957, he said the following about the above charges. The evidence does not support a determination that Juana Torres was fired due to her union involvement. Moreover, concerning Dominador Gonzalez, after looking at the evidence presented by both sides, this person is fully convinced that the fight between Gonzalez and Janicito was the immediate and main reason why Gonzalez was fired. Having reviewed the facts submitted by the parties in the Honorato Gabriel case, the undersigned is confident that Gabriel was not fired as retaliation for his union activity.
This case between the National Labor Union, who acts as a petitioner, against the respondent, Insular-Yabana Tobacco Corporation. The legal issue presented in this case is the unfair labor practice under Republic Act 875, charging an employer of discriminatory dismissal of an employee because of a union activity. Republic Act 875 is a labor policy to eliminate the causes of industrial unrest or employer-employee disagreement by encouraging and protecting the exercise by employees of their right to self-organization for the purpose of collective bargaining or negotiation of wages by employment union, and for the promotion of employees' moral, social, and economic well-being. Due to the discriminatory dismissal of an employer to the employee because of the union activity, case has been dismissed due to the negative finding that the employer did not dismiss the employee for union activity, and the cause of dismissal was not justified. Hence, the Court of Industrial Relations ordered the reinstatement of back pay of the dismissed employee pursuant to provisions of Section 19 of Commonwealth Act 103, which is an act to import protection of labor by creating a court industrial relations empowered to fix minimum wages for laborers, and to enforce compulsory arbitration between employers and employees respectively, and by prescribing penalties for the violation of its orders.
The facts that have brought the above issue before us will be briefly stated as follows. The petitioner herein, the National Labor Union, filed charges against the respondents Insular-Yabana Tobacco Corporation in Court of Industrial Relations case number 798 PLP. Alleged discriminatory dismissal by the respondent of 2 employees, Juana Torres and Dominador Gonzalez, and charges for discriminatory dismissal of Honorato Gabriel in CIO case number 801 ULP. The cases were heard by Judge Arsenio I. Martinez, who made in his decision of December 26 the following findings on the above charges. As to Juana Torres, under the facts of this case, it may be argued that the company was not completely justified when it dismissed Juana Torres. Be that it may be, still the fact remains that in an unfair labor practice case like this one at the bar, the sufficient and insufficient of the cause of her dismissal is not the issue, but rather where the dismissal of Juana Torres was due to her union activity, as pointed out elsewhere. The evidence does not warrant a finding that Juana Torres was dismissed because of her alleged union activity. It is therefore fully recommended that the complaint in number 798 ULP is insofar it is alleged discriminatory dismissal of Juana Torres be dismissed.
A review of the entire law on the subject reveals the legislator's intention to treat acts alleged to constitute unfair labor practices as violations of the law. or offenses to be prosecuted in the same manner as a criminal offense. The reason for this provision is that engaging in an unfair labor practice is an offense against a public right or interest and should be prosecuted as such. It should also be noted that Section 5 makes no provision for the return or reinstatement of the dismissed employee if the charge of unfair labor is not proven. On the contrary, the law states clearly that if the acts alleged to have been committed as constituting unfair labor practice are not proven, or if the complainant requests that the case be dismissed, the charges of unfair labor practice shall be dismissed. We hold that because the cases at the bar were instituted expressly as unfair labor practices cases under Section 5 of the Industrial Peace Act, and no unfair labor practice was proven to have occurred, the Court of Industrial Relations has no authority to grant remedies such as reinstatement or back pay under its general powers of mediation and conciliation, but must limit itself to dismissing charges of unfair labor practice. In accordance with that, we hold that the majority of the court, the charges were correctly dismissed without considering the merits of the two employees' reinstatement claims, Juana Torres and Dominador Gonzalez.
It should be emphasized that the National Labor Union filed the complaints against the Insularia Tobacco Company for unfair labor practices. In the case of Juana Torres, it was claimed that she was fired because she campaigned actively against the president of the union as alleged in the complaint. Whereas Dominador Gonzalez was fired because he was campaigning for membership to be able to change the president. As to Dominador Gonzalez, after considering the evidence presented by both parties, the undersigned is fully convinced that the immediate and fundamental cause of the dismissal of Gonzalez was the quarrel that took place between him and Junicio To. As a result, it is respectfully suggested that the complaint in the case number 851 ULP and 798 ULP claiming discriminatory dismissal of employees be dismissed. The basis for this provision is that engaging in an unfair labor practice is an offense against a public right or interest and should be punished as such. It should also be observed that the Section 5 makes no basis for the return or reinstatement of a fired employee if the claim of an unfair labor is not proven. On the contrary, the legislation expressly states that if the acts allegedly to have been performed as constituting unfair labor practice are not proven, or if the complainant requests that the matter be dismissed, the accusations for unfair labor practice will be dismissed.